All right, good afternoon, everyone. Welcome to this fourth annual conference of the Stanford Computational Antitrust project. It's a real pleasure to have you here. Before we start, some housekeepings. The afternoon going to be structured in the following way. I first can start with some very brief introduction. Then we have two panels, 50 minutes each. The first panel is dedicated to computational antitrust in 2025, so nowadays. And then we have the second panel dedicated to computational antitrust in 2030, which will be more futuristic, hopefully not too sci-fi, but as realistic as it can be. And we'll conclude with some remarks. This conference is co-organized with Theodora Grossau, who is currently moderating another panel, but she will join us in a couple minutes. And before we start, I have to say again, as I always say, my big thanks to Roland Vogel and to Megan Ma for their support. The project would not exist without them, so thank you so very much. Now, in the project, we have about now 75 competition agencies. We just added 10 more competition agencies. Because this is recorded, what I must say is that if you are the head of competition agency and you are not part of the project, we definitely send you an email and ask you to join. So feel free to reach out to me so we can add you to the project. What we do is that every year we publish an annual report in which we ask all the competition agencies that are part of the project if there is anything they want to share in terms of how they use computational tools, the institutional challenges, the legal challenges, the technical ones, how they deal with all of that. We published 3 of those reports that amounts for about 50 FIHS agencies, and they are currently working on the 4th final reports. Everything is open access, so again, feel free to visit our website. It's computationalantitrust.com, and you get access to everything, including papers that we publish. So far this year, we've been focusing on our podcasts. We interviewed the head of several competition agencies. And this year, we will release more papers that we ever published coming from top academics, but also some enforcers. And we have COF paper. So if you have anything you'd like to share, send us a short abstract and we can take it from there. All right. So very briefly, before I go on the panelists, what I want to say is that when we started the project in 2021, in January, very few competition agencies were for real using computational tools, right? Some of them were doing it, especially the large competition agencies at the time, but most of them were thinking about it. ChatGPT, you have to remember, was not yet out, right? So it feels like 100 years ago in the age. And this was on the radar, but definitely not a top priority for competition agencies. And I'm talking agencies, but it could also be enforcers and policymakers. Now, 4 years later, pretty much all of the competition agencies, at least the ones that are parts of our project, are relying on some computational tools, of course, to varying degrees. Some of them are using deep learning, modeling the entire economy with agent-based modeling. This is very advanced. Some others are doing it in a way to classify documentation and help the case handlers, which is also very valuable. So you see that depending on the needs of the agencies, the region, and their expertise, there are different use of those tools. Now, I think we have reached the point where it is not for us anymore to push for the use of computational tools. In a very complex and dynamic economy, we think it's necessary, but agencies are doing it. What we think the issue that we must discuss relates to machine learning, data accountability, data collection, transparency, which was the theme of our 3rd annual conference. It could also be AI explainability, all of the subjects that we will tackle actually today. Now, I think it's important to say that AI, amongst many other computational tools, has a very deep potential, right? We tend, especially as legal scholars, to focus on the pitfalls and dangers and all the things that we should consider. But the reason why we should consider all that is because of the potential of those tools, whether it is to detect more practices and for agencies to be more proactive in a world where they have less leniency applications, whether it is to analyze the practices and make the analysis more dynamic, maybe rely on complexity science and other that are powered by computational tools, or at least more explainable. It could also be to design remedies, to monitor the implication of the remedies, to better understand documentation that they have. When they do DAO raise and size sometimes billions of data entries, how do you deal with the documentation, and so on and so forth. So that's what we want to cover in today's events. I am very grateful to have a fantastic lineup of speakers. And in fact, I must say that although it is our fourth final conference, this is the first time we can achieve what we've been able to achieve with this lineup of speakers, meaning having not only academics, but also top enforcers, policymakers, and the people working in legal tech, right? So the people who are actually designing those tools and programs and all software that will shape not only what we can do in terms of antitrust, but also, as I'm sure we will discuss today, what antitrust actually is, right? Because we will see that will come down to what it is it for, is that okay to automate, what do we not want to automate, and so on and so forth. So on that, I will call on the very first speakers for the very first panel. So if you will please join me here on the stage, and I will take that opportunity to introduce you. Your full biography is available on the event's website. So you find all the information over here, and we'll see how immersed order will actually put you on the panels. Feel free to put yourself where you feel the most comfortable. What I want to say is that I have a short biography, so to give some context. So right next to me, it is Paula Blizzard, and I'm very sorry if I butcher your name. So I'm sure you're used to that in the United States, but I know how it feels. She is the senior Attorney General from the Antitrust section of the California Attorney General's office, where she leads the Antitrust section, supervising all of the AGs on non-healthcare competition matters, including those against Google, Amazon, Apple, JetBlue, Live Nation, RealPage. I don't know if you've heard of those companies, but there are a couple cases that we may want to discuss. And before joining the AG's office, she was the Deputy Bureau Chief for Enforcement at the Federal Communication Commission. Next to you, Paula, we have John LaBarre. He is the General Counsel at Harvey AI. Now, most of the people in the room and at today's events are well aware of Harvey, actually already mentioned this morning, but to give some context to the antitrust experts out there who may have not yet heard about Harvey, Harvey is a platform, or at least a company that provides a platform to make generative AI useful and accessible to lawyers and other professionals in the legal profession. The company, if the numbers that I have are correct, and please correct me if I'm wrong, has raised recently $300 million USD and has a market cap at $3 billion US. So that shows the importance of such companies, and Harvey's a leader in his space. Prior to joining the company, John was the Vice President's Deputy General Counsel at Snowflake, and prior to that, he was a senior member of the patent team at Google, another company you've never heard about. And last but not least, next to John, we have, and this is when I need to remember exactly how to pronounce it the Brazilian way, Alexandre. Perfect. All right. The president of the Brazilian Competition Agency, the Administrative Council for Economic Defense, CADE, since July of 2021. Prior to becoming the head of the agency, Alexandre was the Superintendent General at CADE for 4 years, and he previously served as a commissioner at the very same agency. And interestingly enough, for the enforcer, at least interestingly from a European perspective, he has a PhD in law from the University of Minas Gerais. All right, on that, I will come and join you on the panel. But I asked the speakers to provide very short answers to very complicated questions, which is clearly unfair. But the goal is to actually come back to you multiple times and to make the panel as dynamic as we can. But before we do that, I will give you actually 3 minutes each to share anything that you feel, not as you, but that is actually of very high importance and that you want people here in the room and online to take with them. So we'll start with you, Paula. Let's begin. Take us on a journey.
Great. Thank you for having me. Do I need to use the mic? Sure. I don't.
I think it's working.
Hello. Okay. Thank you for having me. It'll be to be here. I always have to give a disclaimer, which is I'm speaking only on myself and not on behalf of California Attorney General. So just as a brief opening about this field of computational antitrust, it covers a tremendous amount of things. Some things that honestly we've been doing for 10 years or longer in terms of antitrust document review. That's the easiest, what I think of as the low-hanging fruit, because we have always had databases full of millions and millions of documents, and you can't review them all. So you have various predictive coding strategies and techniques that are going to help you figure out what are the most important documents to look at. I think one step up from that are a lot of the tools that are reviewing government procurement data, trying to find evidence of violations. That is not something the California AG is doing right now, not because the tool wouldn't work, but because there are 1,000 procurement agencies that don't have the data in place, which is just a data collection and cleaning problem, not the review problem. And then I think on the next level up, you've really got many more of the AI tools that are looking at modeling markets and all kinds of stuff like that. That's probably not admissible in court. So that is fine right now to be giving you ideas about where to look or place until you might get admissible evidence. But in the U.S. system, which is different than Brazil and many other countries, we have to satisfy certain standards to bring evidence into the court. Because we are a prosecutorial agency and not a regulatory agency. So that I can is quite a bit farther out for the U.S. agencies. That'll stop that.
So my name is John, and just to remind you, I work for a legal tech company, so please feel free to take everything and say with a grain of salt, right? But, the one, I'll use my 3 minutes maybe just to sort of ground folks on sort of like a common vernacular around AI, because I think a lot of different terms get thrown out in lots of different ways. And so the way I currently view the current state of the art of these generative AI models and how they're being used in legal practice, broadly speaking, it's kind of like 3 phases. Like the first phase is sort of the phase that we're probably most familiar with, where AI helps us, solve the like page problem, or helps us do research chats, or a lot that Paula was talking about, which is, and where this technology really shines today, is dealing with large amounts of unstructured data, right? It's really good for helping you find needle in the haystack. It's really good for helping you cull information, summarize information for large tracts of data. And then, starting this year, and various vendors are calling it different things. Workflows, as I said, is a common one. But really, it's this notion that instead of you just going to your AI and tool and asking it to do something for you and then taking the output yourself, doing something with it, AI will now sort of collaborate with you, right? So AI will understand what it is that you're ultimately asking to do, or the kind of work product that you're ultimately trying to create, and then it will try to help you build to that end state over the course of the project, rather than just sort of giving you a discrete answer and then waiting for you to tell it to do something else. And then the third phase, which is maybe not 2025, but close to 2025, will be sort of the more agentic stage, where you ultimately get comfortable with these tools and you ask the tool to do something and give it limited amount of agency to go and do it. Like, and the example that I always go to, this is the one that would help me immeasurably in my day-to-day practice, is if I had an NDA agent, and anytime a company wanted me to sign an NDA, or I wanted a company to sign an NDA, I would take my NDA agent, introduce it to their NDA agent. It would know my parameters for what an NDA should be. It would know their parameters, what the two agents would go off and come back and tell us that they negotiated us an NDA and never done, or that they almost negotiated an NDA but they're touring issues that they can't resolve without our input or something like that. This is big, not here today, but you might start beginning to see it in 2025, certainly by 2026. You'll start seeing the tools that sort of do this. So I'll stop there and pass mine.
So, my name is, as I introduced, Alexandre Cordeiro. Thank you very much for being here. My first time in Stanford. It's a pleasure. So, a brief introduction and a Brazilian perspective, especially as the head of the agency, being doing this job for the past 10 years. And I remember when I got in CADE 10 years ago, many things changed a lot. And today, it's completely different. The tools that we were using at that time, and now we're facing the future. I remember that when one of the first cases that I got there was a case about a cartel, very simple cartel of laundries in Brazil. There is no AI issue. There was no discussion. The discussion was, should I analyze this case as a per se rule or rule of reason? Now, it's completely different. Now, my discussion is, how can I have a tool to analyze a merger that is not price-based? How can I understand this new world if I'm not a tech guy? There is a lot of asymmetry of information, especially with second agents. We need to have multidisciplinary people. Inside of the agency, we need to have many economists and also many tech guys. Listen how hard it is and things that we have been facing. Tacit collusion with algorithms. We just opened an investigation a year ago. This issue is still going on. It was about a software that designed algorithms to put prices on the fuel sector as well. So all gas station was using this algorithm. And this algorithm, there is one association of the gas station that was like giving incentives. People use this algorithm. So what we have been discussing is this algorithm a tool to collude or not? If it's not, but the result is a tacit collusion and it's causing harm for the market, should I go on with the investigation of it? I'm going to move on. Say, am I going to buy the result, or I have to see the intention? So, and this is one issue. There is many issues that we could talk about, starting from the idea of regulate or not regulate. If decide to do yes or no, how are we going to do it? Think that regulations, the solution of every problem. This is a good discussion as well, so I'll stay here.
Okay, so I'm not a bit bad at predictions, and already what I did not see coming is that we will touch on what is antitrust in your very first answers, and it was there already. Whether we should go after algorithms that are test peak colluding without mens rea, so without being designed for that purpose. All right, we'll come back to it. Small, easy question. What I've done is that I divided my questions in 3 different parts. First, I want to talk about access to data and how you analyze the data and what you do with this. Then we'll talk about the expertise, regardless of where you're working from, or maybe actually that is very context specific, how you are integrating technical expertise with the legal one, and how the challenges that you may have encountered. And then we want to talk about institutional design. So how is your institution working? Has it changed? Should it change more, or should, the country retain strong legal basis? All right. Coming back to data and access to data, analyzing data. The first question that I have is for you, Paula, Alexandre, where I want to just rewind a bit before we talk about using those tools and ask the question about the data that you need for those tools to function. As we already covered, you do need a lot of data. So my question is very simple. Can you access the data that you need? Or is that an issue that you encounter or have encounters depending on the circumstances and for specific cases? And then I'll come back to you, John.
So that depends on what data you're talking about. So as the California Attorney General, right, we have compulsory process. I can issue a subpoena and get any bit of data from any company in the state of California. I can get it for text message, or I can get it for email, I can get it for database, if it's relevant to my antitrust investigation. Okay, so, but with that ability also comes tremendous responsibility, right? That I cannot willy-nilly subpoena everybody for everything. So there's multiple questions here. If I have an open investigation into a company, can I get the data? Well, yeah, I can subpoena the data, right? And I can get it into a database. And what I want are all the emails, because I'm going to try and figure out if there is tacit collusion using a software algorithm, then, the presentations to the board, the CEO, and the bottom-level programmer's emails about what he was actually doing when he made these changes to the software may tell me that. But step number one is, okay, I now have 10 million emails in a database. How do I find what I'm looking for? So this is where some of the predictive coding, it's called technology-assisted review. It's called continuous active learning for technology-assisted review 2.0. Has a whole bunch of different names, but these are tools that have been developed over decades and continue to constantly be refined. So that's one type of data. But another type, which you were mentioning briefly, and a lot of countries have looked at, is procurement data. Right? So California is obviously a massive state. We have a $300 billion budget. A lot of that is procuring things, and we are always on the lookout for procurement fraud. So would I like to get every single bid that is submitted in a standard format and the winning bidder and the contract terms in a database for the entire state, every single state and local agency that I could look at and use data mining to figure out if there was bid rigging and procurement collusion? I would love that. That data I don't have. And that is a fact that just arises from the fact that these are independent agencies. These are separate groups that it's just not pulled together. And so that is a data gathering, cleaning, organizing, and standardizing problem.
So this is a very general question, and I can answer it in 3 ways.
That was the purpose of me asking such a broad question. So that's okay. You said whatever direction you prefer.
So the question is, can I have the data that I want? All that I want? No, but some, yes. And the thing is, if we're talking about mergers, it's one thing. If we're talking about conduct cases, it's another thing. If I'm talking about advocacy, it's also completely different. But let's stay for now in conduct cases that is big enough to talk about. So I can get any data from anybody that I want. I can ask if they would say. I can do a downweight, get the computers, bring everything inside, and analyze using a lot of tools to do the monitoring data and looking for what I want. But one important thing that I have, different from you, is since 1997, I have all data from all public procurement that happened in Brazil. the value of the bids, the name of the company, who gives the bid, the partners of the company, the relationship of the party with the other companies, the custom days, the company contracts, the IP of the computer, everything in one database that I can analyze and see if there is red flag, yellow flag of collusion or not. So in 2013, we developed an algorithm using the Abramson from NYU paper and this idea to develop this algorithm and understand the relation between pricing and profits, and to analyze all these data. And the output is here probably to have a collusion or not. And using this picture, start investigation. Many of the Brazil cases that we have right now begun with this tool. And this for authority is so important because if we have a proactive way to investigate, you're not depending on lenience programs. So we start the lenience running and we become more strong. And if people has to think, okay, they are doing something, they can get me anytime. So it's better go there and collaborate. So this is really what happened, and imagine the amount of data that we have for all companies, all bid in Brazil since 1997, with even the euros of Portuguese that they give in those bids to analyze the standards of those companies.
Thank you, making someone very jealous panel. Jill, and I also want to ask about the data. I made those other questions you can't answer, but I will still ask the question. So you have the domain-specific AI, and I think it may be also worth taking a couple seconds to answer the question of why can't I just use ChatGPT, right? Because, well, we won't get to the same results, but you can fit that good. My question is, which data are you using for the purpose of training your domain-specific AI? And do you have anything that is antitrust specific, or is it not necessary? Because it may still emerge and you may still have the antitrust understanding.
So the purpose of the company that I work for, Harvey, is to make generative AI useful in context sorters. And what the company does is it takes the general purpose large language models that are out there, OpenAI, Anthropic, Google, and says, okay, for any given question, which is the right model to use. And within those big companies, there are lots of sub-models, right? So we break down sort of the question, and we get some internal heuristics to determine which model or models are going to help us get to the right answer. And when I say get to the right answer, I mean we want to provide it and present it to the user in a way that's useful to the way it's useful to a lawyer, right? And so a lot of what we do on sort of the back end is we have a whole, I love to say that Harvey is the company with the most lawyers per capita of any company I've ever worked for outside of a law firm. Because not only do we have sort of a traditional legal team, we have lawyers who are on the go-to-market team helping sell, but we also have lawyers who work hand in hand with our product team to actually build the product, to analyze the output and refine the outputs, so that we're making sure that we're giving output that's useful to lawyers. And part of that is for heuristics, part of that is training, part of that the kind of data that we use to help modify the result, the models to get to the right kind of output. I just hard feedback on something that Paula said. So 10, 15 years ago, we started seeing technology assisted review, right? And so when technology assisted review first came on the scene, nobody liked it, right? And the reason nobody liked it was because people would look at the output and they say, oh, we got this one wrong, we got this one wrong. And they're like, oh, it doesn't work. It sometimes gets it wrong. But then the technology uses to review people push back a little bit. The companies that were making the same pushback is but humans get it wrong too, right? And so there are these whole hosts of studies that were done in all different kinds of review scenarios, and they showed that human reviewers are accurate approximately 80 to 82% of the time. It was funny because there were so many different studies that were done, and they all consistently came out within that kind of slightly narrow range. And so the technology-assisted review companies were able to show we get it right 92% of the time, or something greater than 82% of the time. And that's when it was about to the races with technology-assisted review. Because they were asking the wrong question. Does it ever make a mistake? Yes. But that wasn't the right question. Does it get it as good as, or approximately as good as, human reviewed as? Yes, that was the answer. And so with everything that we try to build, we try to make sure that we're achieving like human level, realistic outcomes for the task given to us.
All right. So once you have the data, the question becomes whether you can use it, knowing that decisions, depending on the institutional design, but may end up before the courts, right? And so the question for you, Paula, is, and I think you will have to correct, because I have to pronounce it the French way, you have the Supreme Court case, LaBarre. So maybe for everyone on there, you could say it's the American way, which would probably be more appropriate. But in that court's decision, you have the standard for what is admissible in terms of proof before the courts. Now, my question is whether you think, and you already touched upon that if you are to just on predicted and modeling and best guessing of the future, this will be rejected. Do you think that Supreme Court's decision is well adapted to today with computational evidence? And how likely you think computational evidence will be accepted in the future?
Sure, thank you. I feel I need to do my database team a little bit of credit. We do have some procurement databases, but they're not nearly as good as they are in many other countries. It is our independent streak here in California. So we absolutely can do incredibly detailed computational analysis in court. Right now, we do it in every single case. This is the type of econometric analysis that has been done for a long time and has been ramping up and getting, from my perspective, more and more expensive every year. These guys and gals.
And it's incredibly detailed, and we are looking at,
we have obviously some of the biggest companies in the world, and they have an amazing amount of data that they are tracking about everybody, every moment, and everything you purchase, and everything you search for, and every way your mouse moves. Okay, and we get that. And then you have to figure out how to analyze it. So just storing it is incredibly expensive, let alone running it through it. And we do that. But the way it comes into the U.S. court, and what is different than the U.S. courts than in most of Europe, not Austria. Austria is procurement-based like we are, but in most of Europe and South America and various places, those are regulatory agencies which can analyze the data, put everything together, come to a conclusion, and essentially write the opinion. Okay, they are sort of the prosecutor and a bit the first level judge to make a decision about what's a violation. The U.S. doesn't work that way. I do that analysis. I get an expert to write a very detailed report, and then I have to go into court. And then the other side writes a very detailed report. And if you've ever met two economists who will get 4 opinions on any given topic, right? And so there is always a Nobel Prize winning economist on the other side and some Nobel Prize winning economist who's come to exactly the opposite conclusion. And so before I can get anywhere, I have to win that battle with the experts, okay? And so that is just the way our system is set up, that it is prosecutorial. So what that means is there are all these standards. We usually say Dobert, and as I booked LaBarre, I've heard different views on how he himself pronounced it, which we could be governing, but who knows. The California State Court is called Sargon, which is easier to pronounce, but that's in state court, similar standards that say, when do I let expert testimony in? And the judges are very much designed to be gatekeepers, that's the phrase, to keep out what they call junk science, which other people would call innovation. And so it's complicated. It has to be accepted at a certain level. It has to be peer reviewed. It has to be something that the other side can attack and it will stand up, right? Because I can't go in with something that isn't going to stand up against the absolute best economists in the world that Google, Apple, Amazon hired on the other side, right? So we can use a lot of techniques. But I would say generally our system tends to lag a little bit. That it's not a place where you can come in with something incredibly innovative because either the judge won't let it in and the other side will attack it as being crazy and argue that it should be thrown out. Or it will go up against a more traditional method on the other side and we will sort of lose the battle of the experts. And so that is just the way our system is set up.
Very nice. Now, the question I have for you, John, is, and of course you have a legal background, so I kind of expect upon the answer, but how much those standards are considered when you are designing the products? Is it part of the thinking or is it not? It's a very provocative way of putting it because I cannot know.
Yeah.
It is, but
So we have the saying at Harvey, and it's not something that we coined, but it's something that we like to say a lot. AI is not going to replace lawyers, but lawyers who use AI are going to replace those again, right? And so we don't approach our problem set from the perspective of like, oh, how do we design a function or a feature that's going to replace a lawyer in the I did it that. Well, the way we design our product is we say, how did an AI make a lawyer who's in the loop more efficient on what they're doing, right? And so, you know, when you were talking about, I'm going to mispronounce it too, Dalbert, you know, I was thinking to myself, oh, what would happen if you tried to take an AI, completely AI-generated expert report and enter it into the system? Was that where you're going with your question? But I don't think, you know, we certainly would encourage anyone to do that. But I think in practice, the way these tools get used is, okay, you could put in a whole bunch of data into one of these systems, and you could say, here is an example of an expert report. And you could say, I am the plaintiff, Brian, the defendant in this case. Use this special report as an example. Use the data over here to support your claims. And here's what I want your expert report to cover, right? And it will spit out a first draft of that expert report for you, right? And then the expert will have to make sure that they agree with every single word that's in that report. We change the things that they don't agree with and stand straight. So I wouldn't see it as a tool to sort of replace what the expert's doing or the role of the expert or the role of LaBarre or the court in sort of gatekeeping what does and doesn't get into the court. But I do see it as a way to facilitate, you know, taking a shortcut around some of the work that you have to do to get there. It's some expense with some of these experts, which are quite costly to get there. And that's where I see the world going in 2025. Now, if you ask the question, 2030, that you read up needs.
all right. Let's talk about expertise because it has been kind of underpinning our conversation so far. And the question is, will you add some? And feel free to react to what you just heard. But my question is this: how many technical people, being more specifically computer scientists, data scientists, do you have within the agency and or economists with this kind of expertise? Has it changed over the last 5 years? And how are you using those people to indeed, when then the decision gets spilled, you know, be in a good place so that everything won't actually fall like a castle made of sense?
Yeah, I was studying at 2013 and developed this algorithm that calls GRAIN. It's a GRAIN project, and we had some very technical people in tech issues and also economists to develop this algorithm. So the group was huge, was 3 people. So, and now we raise a lot to have probably 5. Double, almost double. But we have 30 very good economists. CADE is a small agency. We have 230 people, technical people working on cases, just 230. 30 are economists, the rest is lawyers and other professionals. We do have a group of tech people, But you can hire consultants from outside to help us to develop some project. And every day we're looking to increase our capability to understand better what is going on in the tech world. And we also have a project to develop an antitrust AI to help us not just with cartels, but also with merger and acquisitions. So we have the time of analysis of a merger in Brazil is around 22 days. When it's fast track, we have like 12 days. But what we want to do is in 10 seconds. As soon as we get a lot of information for the past 30 years, we need something that when you fill up the form and is a fast track, I give the answer in 10 days. In 10 seconds. But I do have 50 days to request the merger if there is some information that is misunderstood, was not correct, or they need a gift that they should do it. So the idea of the issues is every day step forward to being the AI tools, more technical and multidisciplinary people to work for us, because we really understand if you're not getting this rule very deeply, you're not going to survive.
Now, let me ask you the question, Joe, because it's rare to actually have the opportunity to amass someone working for such a leading company. How is the company structured? So how many, and can be approximates, how many computer scientists or technical people do you have versus how many lawyers? And when it comes to antitrust, again, I come back to this kind of question, but do you have antitrust experts, lawyers, or not, because it's beginning may emerge out of the data that you have already?
So our co-founder was actually an antitrust lawyer. They call him a recovered lawyer because he no longer practices, but that is background. So we're a relatively small company, right? So we were founded in July of 2022.
And I think if folks are thinking about, like, what does that mean in, like, ChatGPT? Like, ChatGPT came into the zeitgeist in November of 2022. So right before that is when we were founded. And for our early days, for the rest of that year, we were probably about 6 people. And then from the beginning of 2023 to 2024, we suddenly got some traction in the market, hired more people. We actually got some fundraising from Sequoia and Climate Versions and OpenAI. And we grew to about 40 people in a year. And then fast forward to today, we're close to 300 at this point. And I would say that roughly 40% of the folks, 40 to 45% of the folks who work there are in sales. 10% to 20% are G&A lawyers, like traditional lawyers who work in the legal department. And then the balance are on the engineering and product side. And of the folks on the product and engineering side, there are 22 lawyers, right? Plus, we also employ close to 40 contract lawyers as well. At any given time, that number can vary, but that's roughly what it is.
Okay, I have a follow-up question. I'm guessing that it is pretty sexy for lawyers to work for you, so it's probably not that hard to hire them.
So easy to hire the lawyers. It's really hard to hire engineers.
Okay, so that my question is for the technical expertise, like, because in law, I'm told it's not that sexy to everyone out there. Like, how you struggling when they have competing offer, let's say a big tech company pursues to you. Is that something you are experiencing?
The lawyers?
No, the technical.
The technical. So it is a little bit of an interesting problem for us, right? So on the one hand, you've got these large language model companies. They're building, these very large competition complex, playing with,
millions of petabytes of data and, have hundreds of thousands of keys at their disposal to create all these different models and do different checkpoints and things like that, right?
And that's not what we're doing, right? So we're not trying to compete with the large language model providers. And so we're not trying to compete with the same talent that they are. But there still is a sexiness to working. If you're an engineer, you want to work at the hardest problems, right? And so there is a little bit of that going on. Plus, there is just a natural inflation for, salaries for all these folks, right? Because there is a quest for talent in that space. So it's not, but we also are, there's how Harvey described itself, because we're not, making the large language models. We're an AI application layer company. We sit between the models and we create applications that are based on the models. We make them useful in our contents. So the vertical that we serve, right? And so there's going to be a lot of companies that grow up in that space, but we're amongst numbers, right? And from that perspective, it's kind of cool to work for us too, right? And so there's a little bit of a, we're not necessarily as sexy as, working for OpenAI as an OpenAI researcher, but we're still kind of cool to work for. And we got a great vibe. And so it goes both ways.
All right. So now to you, Paula, how cool is it to work for you? And you mentioned that, the costs of acquiring the expertise are going high. So, and you mentioned also that you've been using computational tools for a long time. So is that a struggle? Do you track talents? Is that something that you are very much always looking for, or how do you position yourself?
Sure. So in terms of the tech, honestly, we outsource it, right? We hire people for particular projects, particular cases, for particular data sets, for particular analyses. So we are contracting out those things. In terms of attracting lawyers, we're the most important law firm in the country right now. Full stop. Depending on how you feel about what's going on in Washington, right? That is mostly, we are here to defend your rights. Day one. And so it is, it's very sexy to work for us right now. We are defending the Constitution. So that's not an antitrust question so much. But that is exactly what your Attorney General, for all of you in the room, your Attorney General is doing for you. So, yes.
And in terms of in-house technical expertise, none of the AGs, we are pushing a direction to acquire them to internalize the costs and actually reduce those.
So let me go back to the antitrust question and the tech question. We can absolutely have some people in-house, some AGs do this, some areas do it. We have found that it's better to go on a case-by-case model because the data sets can be very different, because we often sue with other attorneys general. Sometimes we sue with the federal government. Okay, so who's actually got the data? Is it me or is it Bjork? Right? And so it makes more sense for us to go case by case, hire people who analyze, who can come in for a short project and analyze the data set that we're actually looking at. Yeah, there are absolutely some people in the AG's office focused on this. I'll tell you, obviously one of our biggest areas for tech is security, right? We are attacked all the time. We have everybody's data. Both all the companies, we also have all the criminal records, we have your tax records, we have the government, right? And so maintaining the security and keeping that locked down, and then finding vendors we can work with. Like we also don't send a lot of data out, which means there are things I can't use vendors for, right? Or I can only have tools that I bring in-house and certify myself. So, but back to antitrust, generally we outsource it.
Okay, perfect segue to farm number 3, showing that urgent order actually works once in a while. The question is for you, I saw. How comfortable would you be with the idea of sharing data, standards, protocols with other accomplished agencies or maybe other agencies within Brazil? And Is it something you are doing already? Are you pushing in this direction? Because I could see when it comes to international cartels why you may want to have access to more data. Now, do you have it? Would it be a good idea?
First of all, you did have asked, but I want to say that there's that word two times as well. This is that
US, especially because it's in Brazil, so it's.
But yes, international cooperation is one of our main thing that we have been doing for the past 20 years, and sharing data, best practices, and sure, we have to follow the law, waivers, and everything. Some data we cannot exchange because the law doesn't allow us to do it. But the idea is, I want to share the most data that I can. This is very important for the antitrust community. If you're having the same cases, it's very important to get a waiver and share this data. But a lot of those data are important, for example, to U.S., to California, but it's not important to Brazil. Market is completely different. That's why not just the amount of data is important, but the quality of data is important. Sometimes to have a case, I need more data in the United States, in that case specifically. Sometimes not. So that's the importance to be in this kind of event, to meet Paula, and if she did anything in Brazil, because maybe we'll have a case together. And I think that the international cooperation, the best way to do it is pick up the phone and call. Paula's going to call me and say, hey, Alex, we have this case. Yes, I do. Well, it's a Brazilian company. Look here, what can I give to you? So it's the same thing, based for sure in the legal framework and anything. But this is important for them. ICN, OECD, UNCTAD, those formulas are very important for the agencies to, exchange information, but also understand the best practices. For example, Latin America, this great project that I told you have been walking around Latin America, teaching some jurisdictions to how to do it, and the most important things on the algorithms. The most important thing, the data, is if I don't have the data, it doesn't matter about the algorithms. Sure, if I have the data, I don't have the algorithms, it doesn't match anyway. But the idea is, how can I collect the data? This is the most important thing. And to go out to other jurisdictions and, exchange this information, say, do this, do that, teach them, and also learn from them. It's one of the most important things that is driving us and now the antitrust community.
Now, John, how international is your company in terms of the service that you can deliver? And again, I'm going back to the very same question. Will it just emerge understanding on, let's say, EU competition law, or would you have to trade specifically for that purpose?
So the first question. So we are an international company. We have
Roughly 50% of our clients are among US-based customers. And our first customer was CADE-based, our second customer was also CADE-based. We have a lot of customers in EU and beginning to come online in APAC as well. There is some level of aversion behavior, these models on things, and that's actually something, in a lot of ways our biggest competitors are the large language model providers themselves, right? Because as the large language models get bigger, more powerful, smarter, for lack of a better word, we have to say out in front of that, or else, why use us and not use the large language models? And the real trick then, so you sort of alluded to a couple of times now, is making sure that you have additional data. And so a lot of what we spend our time doing is trying to figure out how we can get U.S. case law in the system, how we can get European case law in the system, how we can get this, that, and the other thing into the system. And you do that by lots of different methodologies. You go out in certain circumstances, you can scrape the data. In certain circumstances, you partner with other books who have the data or partner with the data provider themselves to get that. And you bring it into the system. And then you can create, once you have the data from a technological perspective, there are a couple ways to make that sort of available to the system itself. One is you can go back and you can retrain a pre-existing model with that additional data. It's called fine-tuning or post-training that, right? Or the more commonly done thing these days is you create this data set and you index it, and then you use sort of the standard models, but you ask that to reference the data that's in that data set first as part of, you almost extract the data from the data set before you ask the question of the model, and then you say to the model, using this additional data, please answer this question, right? So this is called research augmented generation, but it's a methodology by which you can sort of make discrete data sources available to sort of generic large language models.
All right. Very last question that I will ask all of you. And who wants to go first? Feel free. Be my guest. So we talked about institution and the constraints of all institutions, whether it is because you can't acquire all the expertise you would like, or you don't have all the budget, or you don't have all the data. If you assume those constraints away, which your economists love to do. Which what? Which economists love to do. Exactly. So we model a world in which there are no constraints. What is the computational tools that you wish you can have today already? The thing that will help you so much, or the products that you wish you could develop so that you can sell apps to AGs and all firms. Tricky one, but that's the very last question, so I had to finish with this one. Who wants to go first?
So a question like this, there is no answer for that, because if the budget, if there is no limitation on everything, probably you don't know what ask, because I've never thought about it. But there is one thing. When we start with no limits, we start to change our mind to see things that you don't see when there are those limits, and understand what kind of tool there is outside that can bring inside. For example, if I can pay more salary, higher salary for people in CADE, and I can hire anyone that I want abroad, I could be, the chief of the technical whatever for the big companies on the world. This can be the most biggest, assets that we could have, because I have a specialized person working with them. That was working with them. I could take them out, work for an antitrust agency, and say it's a trick question, and it's a trick answer.
Yep, sure.
What do I need?
So next to team.
What is at tools?
So you can do it all, whatever I want. When I was a little kid, let me share a story. My mom asked me, what do you want for Christmas? And I always said, I want to have the power to generate any gifts that I can, which is kind of your answer, in a sense, if you acquire the best expertise. All right, very nice. Joan, go ahead. Please don't trick me.
So if we assume away money and assume away computational limits, we assume away data availability, I think, in my mind, what we're left with is the finite resource of time, right? So if I have all the data, all the resources, and all the technology at my fingertips, I still only have 24 hours of the day. And so I think what I really want to use that power for is to help me prioritize then that what is the most important things that I should be